This is the lecture video for corporations and corporate governance. And for this week's material, there will be 2 lectures, possibly 3. One separate lecture on corporations and corporate governance, and then under securities regulation, we will probably break it down into 2 lectures. Let's first start off with a discussion of the various types of business associations. This is just generally an overview. Most of you will be familiar with this material. We'll focus our discussions for this week on corporations. We generally have 5 or so types of business associations. We will dispense easily enough with sole proprietorships, which is the default, and estates and trusts. Mainly we'll focus on corporations. We'll mention partnerships and limited liability companies. For corporations, broadly speaking, we have 3 classifications: what we call a C corporation, an S corporation, and we can classify them as for-profit or non-profit corporations. The designation of C corporation and S corporation simply refers to subchapter C and subchapter S of the Internal Revenue Code that deals with taxation. A C corporation is a separate tax-paying entity. It's all corporations are the same type of corporations other than profit or non-profit. An S corporation is, for tax purposes, a pass-through entity, meaning the corporation itself generally does not pay federal income tax. The taxable income is allocated among the shareholders. I should say that for an S corporation, Tennessee is a little bit different. It will tax under its franchise and excise tax an S corporation. For partnerships, we have 3 broad categories. Generally, the default is a regular partnership. A limited partnership is a creation of the state statute, and a limited liability partnership is also one in which it's created by statute. A limited partnership is one in which there are 2 types of partners, a general partner and a limited partner. The general partner has management responsibilities and the general partner has unlimited liability. The limited partners usually are the money partners, and they have limited liability, meaning they only can lose their investment, but they have no rights to participate in the day-to-day management. A limited liability partnership is usually found in family farms, family businesses, and professional firms like accounting firms, law firms, etc. The limited liability partnership basically provides limited liability for persons who do not commit a tortious act, and under a limited liability partnership, you're always responsible for your own tort. A limited liability company has been around for a very long time, much longer in Canada and Europe than in the U.S. The first LLC was sanctioned in Wyoming in the 1970s. Tennessee did not allow for limited liability companies until about 1994. An LLC is generally the preferred type of doing business as a small business of any size. And that's because with an LLC, there is limited liability. You get the benefit of operating as a C corporation with the limited liability and the ability to make your LLC board governed or member governed. And you also have pass-through entity status. It's generally going to be treated as a partnership. In selecting the entity, there are several factors. Possibly the most important of them is the risk factor. Do the owners want limited liability, or will they accept joint and several liability? Joint and several liability, for example, in a partnership, general partnership, is all of the partners with the partnership. There's several joint and several liabilities. That means the partners are agents for each of the partners and also the agent for the partnership. And with joint and several liability, any partner can be held liable for acts of the other partners or for the partnership. You bet the house on the firm. Taxation, probably the second most important. Do you want to operate as a tax-paying entity or as a pass-through entity? Administrative burden. For very large entities, the administrative burden can be heavy. Certainly for publicly traded companies, it's a very heavy administrative burden. But for smaller entities, it's not so. Whether it's a partnership or limited liability company or an LLP or an LP, there is not a lot to it. The ability to create the entities is not substantial. Most people can create the entities by themselves, although they may screw it up after they create the entity itself. For example, it doesn't take a lot of effort or knowledge to create a limited liability company. But afterwards, or an S corporation, but afterwards, you can make your life miserable. Management and voting rights. Who's going to manage the entity? How is it going to be managed? Are all of the partners going to have a say, or just some of the partners going to have a say? Do you want centralized management, or every owner having a say? If you want centralized management, your operations generally need to be in a corporate form or an LLC form. But for an LLC, the charter has to provide for this type of management. For voting rights, similarly speaking, for a corporation, everybody gets to vote as long as the stock is classified as voting stock. Commonly, preferred stock is non-voting, but that's by designation. It is necessary to say that all owners, whether they're limited partners or members of an LLC or non-voting shareholders, all voters within organizations get to vote on fundamental changes of the organization: dissolution, merger, consolidation, etc. An LLC has the benefit based on design that you can separate financial rights from voting rights. There are two different rights in an LLC. Financing rights, which is the rights to receive money, share of the earnings, and governance rights, meaning the voting rights. And you can allocate those however you want to do it. Raising capital. The easiest ways to raise capital is obviously through public means by a corporation. And this is made much more easy under the Jobs Act, the Jumpstart Our Business Startup Act 2012. We'll talk about that in the Securities regulation lecture. Proprietorships. There's only one owner, so that one owner has to arrange his or her own financing. With general partners, it's the same situation. You can add general partners. For a partnership to raise capital, you have to add new partners, and with new partners come the joint and several liability and the ability to manage. It should be noted, however, in all that I've said, for a general partnership, the partners are free to conduct their business as they see fit by agreement. What I've told you about partnerships and with LLCs, these are default provisions. Members of an LLC and a partnership are free by contract, generally through an operating agreement for an LLC and a partnership agreement for a partnership, to establish who will manage. For example, for a partnership, there may be an executive committee. Raising capital for an LLC is somewhat tricky because unless the entity is board managed, it may become unruly, like a partnership. The life of the entity generally is best for a corporation because it has perpetual life, although it should be noted that an LLC now can have perpetual life. In the old days, under the original Limited Liability Company Act, the LLC had to act more like a partnership than a corporation. That meant the LLC had to was dissolved upon the death or incapacity of a member. That's generally not the case now. Let's look at the rights of the shareholders. These rights are rights that you mostly know about, maybe from the accounting and finance course. The voting rights, as we said, there can be voting and non-voting shares. The shares may, under the corporate charter, may be cumulative voting rights. Now, the notion of cumulative voting rights is one under the Revised Model Business Corporation Act, and that's the state statute that deals with corporations, for-profit corporations. Cumulative voting rights are rights that can be placed within the corporate charter or the articles of incorporation, same thing, to allow for minority factions within of shareholders to elect their own directors. In essence, what you have within cumulative voting is if you are electing so many directors, then you can pool your votes. Instead of voting one vote for each director slot, you can vote all of your votes for one person. Next is the right to share in dividends. Most of you are familiar with this. Common shares versus preferred shares, remember from your accounting and finance. The preferred shares are preferred as to dividends. Dividends have to be paid to preferred shareholders before they're paid to common shareholders. The common shareholders have the right to the residual interest of the corporation, meaning after the preferred shares are paid off, everything else in the corporation belongs to the common shareholders. This is the risk of common shares versus preferred shares. Next, there is a right to inspect the books and records. I believe it's a 5% interest. If shareholder owns 5% or more of the corporation and has a good faith reason for inspecting the books and records, then that shareholder has the right to do it. Next, the appraisal rights. They are also called dissenters' rights. Under the revised Model Business Corporation Act, these are rights of shareholders in situations of business combinations, mergers, consolidations, and purchases of substantially all of the assets of another corporation, generally reorganizations. And with dissenters' rights or appraisal rights, a shareholder who does not agree to a merger, for example, has the right to dissent and be paid for the fair value of his or her shares, not the fair market value, the fair value, which takes into account intrinsic value of the corporation. Shareholders' meetings, there has to be at least one shareholder meeting annually. It can be in the state, it can be out of the state, it can be in a foreign country, it may even be by electronic means. There's a right to an annual report, and this is not the 10-K report filed with the SEC. This is simply basically a set of financial statements, including the audit opinion if there is one. And then there's a right to amend the articles of incorporation. The shareholders create the corporation, and they have a right to amend the articles of incorporation, i.e. the corporate charter. Very briefly, for the directors have management rights. The directors are responsible for the day-to-day management of a corporation, not the shareholders. The shareholders get to elect the directors, and they get to vote on fundamental changes of the corporation. But they are not responsible for the day-to-day management. They can fire a director if they don't like the way the company is run. The same way with an officer. The number and compensation of directors, there is no requirement for a director of a corporation, for-profit or non-profit, to be paid some compensation. Obviously, the more time it takes or the more risk that's involved, especially for a publicly traded company, there will be compensation. The number of directors, there can be as little as one director, but the number of directors are established either in the Articles of Incorporation or the bylaws. The directors are elected by the shareholders, generally with majority vote. The bylaws are can be created by the shareholders. And generally, when the company is incorporated, the bylaws are created then, but they can be amended. The meetings, the directors have to have meetings, at least one meeting a year. If the directors cannot have a meeting within 2 years, then the corporation is going to be dissolved. Usually, directors will meet monthly or quarterly. It can be for a small corporation. It can be by electronic means, or if there needs to be a resolution of the board, they could do this by action of consent, which basically means each director can sign off on the action or the resolution without a meeting. Indemnification rights, as we're going to talk about in a little bit under the business judgment rule, directors, like officers, both as managers of a corporation, face potential liability for negligence, a bad vote on a corporate matter, for example. Indemnification is the right to be made whole, to not have to pay for one's actions. You usually refer to it as indemnification and hold harmless agreements. That's what we're talking about here. For example, if you are a member of a not-for-profit corporation, you're not going to get any compensation whatsoever. Why would you want to risk being sued, hauled into court for one of your votes that you made in good faith? And the indemnification provision can be either in the Articles of Incorporation or in the bylaws. And what the indemnification provision does, it says that if a director or an officer is sued based on his or her vote or his or her act as a manager of a corporation, then the corporation will pay all of the cost associated with it. There is a proviso, however. An indemnification of the managers of a corporation will not hold up if the act or the injury to the corporation is because of gross negligence, recklessness, willful or wanton conduct, or intentional conduct. It has to be simple negligence. And then the liability, as we talked about and we'll talk about later. They can be liable for their actions. Officers are elected by the directors. There are basically only two required officers under the revised Model Business Corporation Act, and that would be the president and the secretary. The secretary attests to what the president has done. You can have as few as one director and one officer, and if that person is named in the corporate charter as the manager. Larger companies obviously have more officers. You can have as many officers as you need. Removal, officers can be removed by the directors, with or without cause. The compensation, officers don't have to be compensated. For larger companies, they usually are. And of course, the responsibility is they have the day-to-day management under the supervision of the directors. Let's look at the fiduciary duties of directors and officers. There are a number of fiduciary duties. And keep in mind the notion of a fiduciary is one who is in the position of trust. They owe their allegiance to the principal. In essence, the fiduciary is an agent of the principal. First is due diligence. This is the fiduciary duty to do a good job, to be careful, to know what is going on. To follow protocols. Next, the duty of loyalty. There is a duty of loyalty of partners to each of the partners and to the partnership. And likewise, within the corporate setting, there is a fiduciary duty of officers, and directors to the corporation and to the shareholders. They have to be loyal. They can't act in their self-interest. There's a duty to use good faith, to display good faith in their actions. A duty of confidentiality. You've got to keep the corporation's secret. You've got to keep the activities of the corporation confidential. You can't use them, can't disclose them to others. A duty not to usurp corporate opportunity. A corporate opportunity to make profits belong first to the corporation. The officer and director cannot take over that opportunity for his or her own benefit unless the corporation has first passed on it. The duty to keep the corporation informed of all material facts. This obviously works hand in hand with the duty of loyalty and the duty of due diligence. There is a duty of majority shareholders to minority shareholders, and a duty to the minority shareholders by the directors and officers. Keep in mind that by majority vote, generally the majority faction of a corporation, shareholders, will elect the directors. And generally, if you elect them to do what's in your best interest. But the officers and directors cannot run roughshod over the minority shareholders. There's a duty to account for corporate funds. This is money in, money out. And then there's a duty to comply with the corporate charter. Not to commit any ultra vires acts, they mean illegal acts going against the charter. Let's look at liability and then the business judgment rule. A corporation is liable for its own acts and contracts, whether it acts on its own or through agents of the corporation. When the agents act for the corporation, this is under the master-servant doctrine. The shareholders generally are not liable, meaning all they can lose is their investment in the corporation itself, meaning their stock value will go to zero. There are limited situations in which persons who have been wronged, either through contract or through tortious action, may attempt to sue the shareholders. Now, this is particularly the case when we're talking about small corporations, closely held corporation, where the managers of the corporation are the owners. First is if there are under ultra vires Act, these are acts against the corporation. For example, paying out all of the assets to the shareholders without first paying the creditors, or doing something that's completely unauthorized by the corporate charter. Maybe it's operating in a different type of business function or business purpose that the corporate charter does not allow, meaning it's illegal. The second one is the alter ego theory, and this is liability of the shareholder based on the notion that there's really no difference between the corporation and the shareholder. The shareholder is treating the corporation as his or her own piggy bank, commingling funds, not keeping records, not acting like a corporation. And then third is when there is thin capitalization, meaning the corporation does not have sufficient assets that generally would be required to do business. And this is done purposefully. I'll give you an example of thin capitalization. From the 1960s and early 1970s, in New York City, the Yellow Cab Company was set up. And the Yellow Cab Company was an umbrella organization for centralized management of taxicab services. Now, each corporation, each car, each taxi was set up as a separate corporation. They would make their runs and be managed by Yellow Cab Company, but each car and driver would be a corporation. And these would be old taxicabs of having no value at all. In the case of Lee versus Yellow Taxi Company, there was a lawsuit because the taxi driver was negligent. And the taxi driver was simply an employee of the corporation. Taxi driver not having any money, but Miss Lee was injured. The court allowed a lawsuit against the Yellow Taxi Company as the shareholder because of the thin capitalization. Now, there have been courts that say that thin capitalization alone is not enough. There has to be something in addition to thin capitalization. For example, combining thin capitalization and the alter ego theory, meaning not treating the corporation as a separate entity from the owner. That those two combined would be necessary. When an officer or director, i.e. the manager of the corporation, is sued for negligence, there is a common law doctrine that protects that manager from liability. And that common law doctrine is the business judgment rule. In lawsuits for negligence against officers and directors, these fiduciaries may have an affirmative defense based on the business judgment rule. Affirmative defense. Recall that an affirmative defense is one that has to be pled or pleaded by the defendant. The requirements for the defense of the business judgment rule is that the officer or director must have acted in the best interest of the corporation. Best interest of the corporation. Second, the officer or director must have acted in good faith. So these are the two requirements. Good faith and the best interest of the corporation. And this is only in simple negligence. Again, if the act is any worse than negligence, simple negligence, gross negligence, recklessness, willful or wanton conduct, or intentional conduct, the business judgment rule will not apply, will not be used as a defense. There are several cases generally within the textbook. Let's take the requirement of good faith, the application. In the case of Smith versus Gorcum, here we have a case in which Shareholder is suing the shareholders, the directors, for a vote in an acquisition. There's a special meeting called of the directors, and the directors get to vote on a merger, and then that plan of merger that's adopted by the directors have to be put to a vote of the shareholders. Generally, whatever the directors want, the shareholders will allow. This is just a fact of life generally. I take you to the Carly Fiorina situation as the CEO of Hewlett-Packard in the acquisition of Compaq Computer Company. It was a fiasco. The shareholders approved it, and they lost a lot of money. Well, in this particular case, a special meeting of the directors were called. Now, generally in special meetings, you have to give advance notice, usually of a week, to give them time, the directors time to prepare. And you have to tell them what it's about. In this particular case, there was not a lot of preparation. The chairman of the board asked the chief financial officer to determine the value of the company. And the chief financial officer did not go into great detail, but he had a ballpark value of the shares of the company, the value of the shares of the company. And this was what they were using for the exchange purpose, right? The share exchange, based on that ballpark number. There was a meeting. At this special meeting, the directors who were there to vote on the plan of merger were given an 80-page document. They had not had time to review it in advance or discuss it in advance. Some of the directors, a few of the directors, objected to the fact that there was not a detailed study of the value of the company, meaning they didn't know the intrinsic value of the shares of the company before the merger. How do you know what your company is worth until you actually evaluate the intrinsic value? And they asked that the decision be put off until a further study can be made. Well, the majority wanted to proceed. So in a 2-hour meeting, the decision was made to go through with the merger. It was a bad decision. The shareholders lost money. Now, some shareholders had the right, obviously, of appraisal rights or dissenters' rights. Some did not elect those appraisal rights or dissenters' rights. But they voted against it. The shareholders then, after they started losing money because of the valuation, sued the directors who voted for the sale of the company at that ballpark price. The Delaware Supreme Court, and keep in mind that the best jurisdiction for handling corporate matters is Delaware. The Delaware Chancery Court, the Delaware Court of Appeals, and the Delaware Supreme Court. Most large publicly traded companies are either incorporated or have been reincorporated in Delaware, generally for tax purposes, but also because generally the knowledge of the courts. We get our best corporate law from Delaware. Well, the Delaware Supreme Court voted in favor of the shareholders and against the directors, meaning held them liable, because the business judgment rule, which had been pled as an affirmative defense by the defendant directors, the business judgment rule didn't apply to them. The court held that they, in voting for the merger with so little information and with so little study, that they had made an uninformed decision. And because they made their decision uninformed, they did not meet the good faith requirement of the business judgment rule. There are other cases we'll talk about in the reading. We'll pass, but the application of the business judgment rule. Situations where the business judgment rule did not apply because there was a failure of loyalty. They breached the fiduciary duty of loyalty, and in breaching the fiduciary duty of loyalty, there was not good faith. One case that comes to mind is the failure of the directors of the company to have adequate internal accounting controls. This was before Sarbanes-Oxley. There was liability there to which the business judgment rule did not apply because they had a duty of loyalty to protect the corporation from fraud, and they didn't do it. Another one, NCS Health Care, in which there was the directors, officers and directors of the corporation refused to act on assertions by the Food and Drug Administration that they were not complying with regulations. And there were fines, and the fines kept growing and growing. They later became very large fines to which the corporation had to pay, and the shareholders sued the directors for not properly managing the corporation. Again, the business judgment rule was pleaded by the defendants, and the court held that the business judgment rule didn't apply because there was a breach of the duty of loyalty. We're going to have a separate discussion on securities regulation, but we need to talk about at least an overview here. The federal regulation of public corporations. Basically, there are 5 laws, big laws. Securities Act of 1933, and keep in mind that these have been amended, so there are small laws, changes over the years. Securities Act of 1933 deals with regulation of the primary security markets, i.e. the initial sale of securities. The Securities Exchange Act of 1934, this deals with the secondary markets, the subsequent buying and selling of markets after the securities have been issued originally. The Private Securities Litigation and Reform Act of 1995, which reformed the derivative action lawsuits. Now, these derivative action lawsuits under the revised Model Business Corporation Act, these are similar to class action lawsuits. A derivative action lawsuit is a lawsuit brought by shareholders on behalf of the corporation. So anything that's recovered goes to the corporation to benefit all shareholders. Lawyers obviously like class action lawsuits because they can make so much money so fast. Many times they're the only ones to make money in class action lawsuits and derivative action lawsuits. But prior to Private Securities Litigation Reform Act of 1995, what you had is a situation where plaintiffs' lawyers would target public corporations. They would look to see that the corporation stock, public corporation stock, had gone down significantly in value. And then they would find shareholders to file a lawsuit, a derivative action lawsuit against the corporation, claiming fraud. Now they wouldn't plead specifically what that fraud is. They would go through the discovery and over time try to find the fraud. Well, the public managers of the public corporations, they knew they were being shaken down, but could not afford the bad publicity and couldn't afford the high cost of litigating, even if they felt they were in the right. So what Congress did, and keep in mind 1995, this is during the Clinton administration and a Republican Congress, they changed the securities laws to require any of these stockholders' derivative suits to alleging fraud to specifically to specify with specificity what the fraud was. This is intended to stop the speculation. Now note the long difference. We don't have a whole lot of new laws in here. The 33 and the 34 Act held up for a very long time, and then in the 90s, in the early 2000s, we had the financial frauds, the problem with financial frauds, and this led to the Sarbanes-Oxley Act of 2002. You probably are familiar with you probably studied Sarbanes-Oxley either in the accounting course or in your managerial ethics course. But Sarbanes-Oxley was sweeping change in corporate management. And then, of course, in 2012, we have the Jobs Act, which is not listed here, but it's discussed in the Securities Regulation lecture. Jobs Act, Jumpstart Our Business Startups Act 2012, for the purpose of encouraging investment in small corporations that create jobs. Let's look at Sarbanes-Oxley in terms of corporate governance. Generally, it was an anti-fraud provision, and it was also to clean up the large accounting firms of these public companies. Remember, Arthur Andersen, LLP, was center stage with WorldCom and Enron, and others as well. But all of the large accounting firms had been sued for negligence, gross negligence under financial fraud. Why was it necessary? Because of the fraud. So you had to target applications for fraud, trying to prevent fraud within the company, to encourage whistleblowing, which became center stage in Enron and WorldCom, and the necessity to make the large accounting firms, the auditors, more independent. It created a lot of cost initially. Has it been effective? Probably not. Keep in mind that many of the problems within the financial industry were not alleviated because of Sarbanes-Oxley. The large banks, for example, the large financing companies and mortgage companies. The features of SOX, probably the primary one of all of them and the most expensive one, at least to date, is Section 404. And Section 404 of the Sarbanes-Oxley Act deals with the internal accounting controls. Section 404 requires all the publicly traded companies who are large enough to be regulated by SOX, meaning they have to meet the public reporting requirements under the Securities Exchange Act of 1934, meaning in terms of revenues and the number of shareholders. All of those covered companies have to have a set of internal accounting controls applicable to management and the financial people to detect fraud, to detect and prevent fraud. And Section 404 requires that those internal accounting controls systems be evaluated. Generally, annually, within the audit process, they have to be evaluated for effectiveness. The second one is the certification of the financial statements by the Chief Executive Officer. They were required, the Chief Executive Officer was required to sign the certification that that the CEO was not aware of any fraud, that the financial statements did not contain any fraud. Now, this was generally not overly effective because if you take you to the case, the prosecution of Richard Scrushy, founder and CEO of Health South, who was criminally prosecuted by the Department of Justice under this provision of Sarbanes-Oxley when Health South was determined to be riddled with fraud. 5 chief financial officers testified that Scrushy, as CEO, had to know about the fraud because of the directions that they were given, but a jury acquitted him. SOX requires that such covered public companies have a code of ethics, and that the code of ethics must contain whistleblower provisions. Furthermore, the whistleblowers must be offered protection under Sarbanes-Oxley. SOX provides for federal liability, criminal, and civil for fraud. It established the Public Corporation Oversight and Accountancy Board, and this board regulates the large audit firms, CPA firms, Big Four and the nationals, and any regional firms that audit covered public companies. They can write rules on auditing. SOX limits these public accounting firms to audit these large public companies to limit their revenues to no more than 40% for anything outside your typical type historical public accounting services: tax, audit, and management advisory services. So, for example, Arthur Andersen, before it split up into Arthur Andersen LLP and Accenture, the Accenture part was driving the firm, meaning it's the consulting side, the auditing, the internal accounting controls, the manpower services, the computer programming, and so forth. And so now we're limited. So these auditors of these large companies, they can't simply be looking at the business revenues from the clients to overshadow their judgment on the audit. And lastly, SOX requires the accounting firms that audit these covered companies to rotate the audit engagement partner every 5 years. The firm does not have to change, but the audit partner with the responsibility for it have to be there. Also would keep in mind, that's not listed up here, but SOX requires that the board of directors of these public companies maintain an audit committee, and the audit committee must have as a member at least one person who has expertise in financial accounting or auditing. Now this blends in with the whistleblowers because it gives somebody to talk for the whistleblowers to talk to and somebody to assess risk. This ends this lecture of corporations and corporate governance. The next lecture will be on securities regulation, protecting the investor.